2021 meeting of the Bloomington Charter Commission.
I am.
Okay.
Oh, did you catch it all?
I did.
Okay.
All right.
It's Adrian's first time doing a meeting, so I might have to
Oh, absolutely.
signal a couple things. And Mark's going to do, or the Chair Thorson's going to do a couple of extra things, like for example, repeating the motion, and the motion maker, just to help out Adrian.
Right.
His first time. So.
All right, and the first item on the agenda then would be to appoint a recording secretary. You have any comments?
Sure, thank you. Thank you, Chair. Chair members, Ms. Christensen, the current recording secretary, has taken a different position with the city and is now working as an assistant to the city manager. And so it would be appropriate, her duties have been transitioned to Adrian with regard to the Charter Commission. So it would be appropriate at this time to entertain a motion that's in the packet on page 2 to appoint Adrian. Adrian, remind me how you pronounce your last name? As the recording secretary for the Charter Commission.
I make that motion.
Motion by, this is a motion to appoint Adrian to the recording secretary for the Charter Commission. We have a motion, I believe, by Stanley, was it? And second by Lindell. We can do voice votes. All right. Any discussion? If not, all those in favor signify by saying aye.
Aye.
Aye. Motion passes unanimously. Before going on to our organizational business, I will do what we typically do, is just go around the table, especially since we have a new member here, and just quickly introduce yourself and say something about your, I guess, how long you've been on the Charter Commission and how long you've been in the city and so forth. Doesn't have to be very long, but a quick introduction. We'll start down at the end with
John Stanley. I've been on the Charter Commission a couple of years. Time flies.
It does.
Especially these days. I'm a almost fully retired investment advisor. That's good enough.
Good enough. Ms. Hunt.
Cynthia Hunt, I've been on the Charter Commission for 20 plus years, I think. You and I are, anyway, chaired the Planning Commission for quite a few years ago. I've been on the Port Authority for probably 10 years, and I do commercial lending with U.S. Bank.
Jay Taylor, retired. I'm an accountant by trade, and been in Bloomington 45 years, and probably the commission now about 15.
It's hard to hear and speak with these, isn't it? I know that. Yeah, I'm Ronna Lindell, and I've been on the Charter Commission. It's my second term. And so I don't know how many years that is, only 6 years. And I've been a resident of Bloomington since the 80s. And I'm retired. I worked for the ESL St. Paul for 40-some years in community development area. So I'm very well acquainted with local government from those years. And I have a couple kids and 3 grandchildren. Glad to see everyone again in person.
Good evening. I'm Melissa Manderscheid. I am the city attorney for the city of Bloomington. I've been at the city for 5 years, and I also serve as the attorney to the Charter Commission.
Mark Thorson. I've been on the Charter Commission forever, I think. It's what I don't even know when I started. I'm also on the Housing and Redevelopment Authority, and I've lived in the city about 35 years.
I've been a resident of Bloomington for 25 years. I've been on the Charter Commission. This is my 2nd year. I've retired. I've spent most of my life in financial management, CFO kind of activities for a variety of companies. In the later years as CFO for several nonprofits.
I'm noticing that the financial people
Yeah.
are able to be retired. That's
Yeah.
really impressive. Next.
Jim Goodermont, longtime Bloomington resident. This is my second term on the Charter Commission. I did 2 terms on the Park Arts and Rec Commission. Not to be bragging, but my grandchildren are 6th generation Bloomington residents.
Wow.
So that's about it.
Thank you.
Thank you all for the warm welcome. My name is Nicole Kohler. I go by Nikki with friends. Please call me that as well. I've been in Bloomington for 6 years and I'm from the sports world, but I'm a community manager.
Welcome.
And my name is Steve Peterson. I've been on the Charter Commission since 2015, I think. I've lived in Bloomington basically my whole life. Day job, I'd like to be retired like some of the folks.
Me too.
My day job is I work at Microsoft on digital video stuff. So if you want to talk about nerdy computer stuff, come afterwards and twist my arm and I'll talk to you. I was on the city council from beginning of 2000 until the beginning of 2014. I've been on the board of the Port Authority along Cynthia Hunt. Started on that about 2012. Is when I started on that. Prior to being on the city council, I was on the planning commission for 4 years, and I was the chair for the last year before I joined joined the city council. And welcome, I'll say. This is an interesting group. It's a little bit different than any other commission that the city has, because we're kind of our own thing and not created by the city council. So that's an important thing to do.
Thanks, Steve. And since we have not only 2 new staff to the Charter Commission, but also you're both new to the city, so I'll have you guys introduce yourselves as well.
Sure. I'm Christina Scipione. I am the city clerk. I've been here about 6 months, and I'm very excited to be here in Bloomington. I came from Egan. I was the city clerk there for 10 years, and prior to that, I worked for the City of Independence. A local government nerd. I love local government. So even though I worked in Egan, I'd still pay attention to what was happening in Bloomington, and so I'm very excited to be here and part of the community here.
Welcome.
Thank you.
My mom is an election judge, and she had very positive things to say about me.
Oh, good. I'm glad.
So realize we're all, we're all
together.
Hi, my name is Adrian. I've been a Bloomington resident for my entire life, and I'm coming over from U.S. Bank, where I was in the anti-money laundering division, but left that so I could take some accounting classes part-time and work on this part-time. I've been at the City of Bloomington for about 4 months now, and my official title is Legal Administrative Assistant. But I'm also the liaison for the Charter Commission, so it's a pleasure to meet you all.
Thank you. Welcome. All right, on to our organizational business. The first item is 2.1, or I'm sorry, 2.2, Charter Amendment to Section 2.05. We have the staff report for this.
Sure. Chair and members, thank you for coming back together this fall. And if you recall, we mentioned that we might need to come back to talk with you again in the fall because we had begun a project when Christina started the new city clerk of going through the specifics of our charter and with an eye towards ranked choice voting and then also with fresh eyes in that with the new city clerk and the opportunity to dig into it as she was working to understand how we do things here at the city. She pointed out some opportunities for improvement, and we mentioned to you that we would be bringing those to you later this year. So we have them in 2 different chunks for your consideration tonight. The first one is item 2.2. It relates to only section 2.05 of the charter. Christina did a great job of the sort of a high-level description and the request for council action, and she has a PowerPoint. The one thing I'll mention to you with regard to the timeline is it's on the bottom of your agenda item for this, and it might seem a little bit longer than we normally have, and that's in part due to a couple of things. The first is that we don't have a meeting of this, we don't have 4 meetings of the city council in October because we're not meeting on the 18th. And we're also not meeting all of the weeks in November. And so the schedule just got stretched out a little bit further than it typically would be when we're meeting all the time each week. The other thing is because of that kind of stretched out time period, and because it's possible that we might not get all of our work done tonight, although we certainly can get it all done tonight, but in the event we don't, I talked with our civil paralegal today, and she and I decided that we will publish on November 4th as well as the 11th. That will give us a little bit more coverage in the schedule to comply with state law, and also because of the lead up time to submit things to the newspaper, we might not know, and we need to get out ahead of that. So, and then there's a holiday, November 11th is also a holiday. So we have a lot of moving pieces this time of year. So that's the one little tweak that we changed after the packet came out. Not an inaccuracy, but I just wanted to make sure that you were aware of that as well. And again, we publish in the Sun Current. So with that as an introduction, Ms. Scipione has a presentation for you on 2.05. And the one other aspect that I'll add before she starts is that 2.05 can proceed forward. It does not need to wait on any sort of amendments to Chapter 5. We can move 2.5 forward tonight. We don't need to wait. And if we happen to act on either of these at a subsequent meeting next week, if that's required, the schedule actually doesn't change, the proposed timeline, because of all those weeks in there where we don't have meetings. So even if we don't get all of our work done tonight, even though we, if it bleeds over into next week, we will stay on the same time schedule. But I also want to just put out there that we don't have to meet again next week. We just wanted to get it on the timeline of our calendar of people's houses because it is tricky to schedule this large of a group of people. So with that as an introduction, Chair, it'd be appropriate to have Ms. Scipione start.
Thank you.
Thank you, Commission members. You can go ahead to the next slide. I had planned to introduce myself before we got into this section of the charter. I had an opportunity to do that. So again, very excited to be here. Thanks for having me here this evening. You want to go to the next slide. So City Charter, Section 2.05 addresses the process for filling a council vacancy. I reviewed this and legal reviewed it for clarity and consistency with state statutes. And we identified 2 potential changes for your consideration this evening. Okay. The first proposed change addresses vacancies in office that occur due to recall elections. So in Section 2.05, there's a list of all the different reasons why a vacancy in council might exist. And so this adds a successful recall election to the list of reasons why there would be a vacancy in the office. And then the second thing that proposed change does is exempts a vacancy in office due to a successful recall measure from the usual appointment process. Because if there's a recall measure, then there's an election that happens for filling that office that's been recalled. And so that recall is not subject, wouldn't be subject to the appointment process that's laid out in the city charter. So this just clarifies that piece of the charter. Okay, the second proposed change that we identify modifies the timing for special elections to hold a vacant position, or when special elections are held to fill a vacant council position. So the city charter lays out the process for filling a vacant city council position. And right now, it currently says that if that appointment process and the appointment is made after the candidate filing period begins for the next regular election, then a special election is held the following year at the next regular election, whether it's a municipal or a statewide general. Candidate filing, we have under state statute a requirement to host a candidate filing and to publish a candidate filing at least 2 weeks before we can open that filing for that office. And so This changes that deadline for holding the special election from when candidate filing opens to 28 days before candidate filing opens, so that we can, if the appointment process is complete, before more than 28 days before candidate filing opens, we would be able to publish that notice and put it on the ballot that November. Otherwise, if it's past that time where we can publish the candidate filing, then it would be placed on the election for in the next general election the following year. So it moves that deadline up basically 28 days to allow for the required statutory candidate filing period. So section 2.05 is
Commissioners,
what?
any questions for staff on this item? No questions? So are both the recommended changes, they're really cleaning up for statutory?
I would say that the first proposed change is to ensure that our charter is consistent with provisions in Chapter 5 regarding recall and acknowledging that. And then the second proposed change is to take into account our statutory requirements for candidate filing. Correct.
Commissioner Stanley.
Just because it seems like it should be asked, if someone were to step out of the woodwork and object to this, what would their objection be? If any?
Good question, Commissioner Stanley. I'm not sure
What's the downside? Why is there any reason why we shouldn't do this?
I don't have a kind of a negative for this particular one. The benefit is we're complying with state statute and we're clarifying language in our code. And not sure that there's a negative to those two.
Yeah. And I would say the first one kind of reduces the potential for confusion or challenges in a way by clarifying. Any other questions for staff?
I'll just add, I'm kind of in the same boat as you are, John. I think this seems like an obvious one that clarifies things and improves it without having a lot of downside.
These days, you just never know where the questions are going to come from.
Right.
Exactly.
All right. Is there any more discussion? If not, I'd be looking for a motion. If whoever makes a motion could just kind of read it from our agenda today to make sure it's specific.
You want the whole resolution or the title?
Just the first part.
Okay, Mr. Chair.
Commissioner Peterson.
Thank you. I move that we adopt the resolution titled, a resolution recommending the City Council enact the charter amendment by ordinance amending City Charter Section 2.05.
Second motion.
Motion by Peterson, second by Hunt. Any discussion? If not, all in favor signify by saying aye.
Aye.
Opposed? Hearing none, motion passes unanimously. And then on to.
I just want to note that one of the best parts of meeting versus now is we don't have to have.
Yes. I would agree. We talked about that.
There's so many reasons.
There's not.
On to item 2.3, charter amendment to Chapter 5. Staff report.
All right, Chair and members, thank you. This is the second one. For those of us that have reviewed our packets, this is a little bit more substantial. So this again was precipitated by an in-depth review by our city clerk and actually our former city assistant city manager, Chris Wilson, as well, before she departed. We learned a lot during the last election cycle about clarity in the process. We also learned a lot when we were preparing for the election administration related to ranked choice voting. We also learned a lot while we watched Minneapolis struggle through the various parts of its ballot questions. And in cooperation with the city clerk, and we took a very clinical eye towards the text in Chapter 5, with an eye towards being very specific. And I'll give you 2 examples. One, we clarified calendar versus business days. We wanted to remove any sort of ambiguity about that. The other is just sort of an example that we did was we stated, instead of saying registered voters, we said voters registered in Bloomington. Now that might seem like, you know, over the top, but we did not want to have a fight with anybody about, well, I'm a registered voter in Minnesota, or I'm a registered voter in the United States, or something like that. So we made a lot of edits, and some of them might seem really detailed, but it was in being informed by the environment in which we all are operating in. So again, there are housekeeping edits that are being proposed, and Ms. Scipione will walk through those. And they're in the first section of your request for council or request for commission or action. They're out there, the 4 bullet points on the first page of this agenda item. And then there was a memo that was prepared by Ms. Scipione that talks about the substantive policy aspects that she will go into in detail tonight for your decision. We talked about the various ways that this information could be presented to you tonight. And we decided to take the approach that Ms. Scipione has in her PowerPoint because so much of this is interrelated. Oftentimes when we're talking about edits, we'll go line by line and explain what we're doing. But because the nature of these amendments and the connectivity of them throughout Chapter 5, we didn't think that that was the best approach. So instead, we took the approach that we have here tonight, and that we'll go through in the PowerPoint presentation. And we'll be stopping. We'll do a quick run through, I believe, of the high points, and then we'll be stopping and having discussion points along the way. You know, we'll just look forward to those questions as they come, and we'll talk through them.
Sounds good.
Commissioners, as Ms. Vanderscheid shared, the purpose of these proposed ordinance amendments, or charter amendments, excuse me, first and foremost to comply with state statute, to make sure that our processes comply with the requirements that we have to follow in state statute. To ensure we had consistency with our new ranked choice voting method, that nothing in our charter disagrees with those or is in conflict with that new voting method. And then we put on a lens to clarify the processes that are within the charter, Chapter 5. And so I put on my election administrator hat, and I thought, okay, if I needed to run one of these types of elections, would this give me the clarity that I needed to accurately and effectively run this election? And would this provide someone who wants to request one of these ballot measures the ability to read the charter and say, okay, I understand, here's step 1, step 2, step 3, and here's the timing. And so that was one of the lenses that we looked at Chapter 5 through to ensure we had that clarification of processes. And then we also looked at it and said, are there any policy changes while we're looking at this that really make sense for the Charter Commission to review and to discuss? And so we've identified some of those as well. So it's a little background information. The vast majority of state election laws apply to Bloomington and apply to Bloomington elections. There are some things in state statute that we're exempted from that allow us to do things like ranked choice voting, where ballots have a little bit different format. But the vast majority of those statutes apply to us. And so some of the statutes that we needed to keep in mind as we were looking through Chapter 5 include a statute that provides us with uniform election dates. And so about 4 or 5 years ago, the legislature enacted legislation that says, cities, here are the dates that you can have special elections, and you may not have special elections outside of these uniform election dates, is what they're called in state statute. We also are subject to election notification requirements. So we as a city are required to provide the county with 74 days notice of any special election that we are holding. we have requirements for candidate filing periods, when they can be held, and when we need to provide notification and publish notification, I should say, of those candidate filing periods. And that timeline depends on when that election is going to be held. And so in state statute, it says if the special election is in November, then the candidate filing period is this many days before the election. If the election is going to be held in August, then it's this many days, and it's different depending on what day of the year we're going to hold that election for that office. And so that is something that we have to follow, is those candidate filing periods as they're specified in state statute, and then the notification for those candidate filings. So we need to publish 2 weeks notice ahead of candidate filing before it opens, and we are subject to that statutory requirement. So the way I've laid out this presentation, as Ms. Manderscheid shared, is I will go through the housekeeping items in a little less detail, and then I will give an overview of the policy items, and then what we thought we'd do is go back to the housekeeping, kind of take questions for the whole list together, since those are a little more brief, and then dig into each of the policy discussions kind of one by one. So to start, here are the proposed housekeeping items that we are suggesting in this amendment. So we are suggesting that we update and reorder quite a few of the section names, so that as we're looking for things in our charter and we're trying to determine, okay, what is this section about? Is it about recall? Is it about referendum? It's very clear to us when we're reading our charter what those different sections are about, and just kind of reorganizing some of them so they're consistent. You know, if initiative discusses different steps in the process in this order, then the referendum discusses different steps in the process in the same order. And so it's consistent from section to section, or ballot measure to ballot measure. The second change is, as Ms. Manderscheid mentioned, changing registered voters to voters registered in Bloomington. So we're being specific, and we know that we are talking about our registered voters here in the city. The third is updating the timing of ballot measures. And so initiative and referendums, the proposed amendment to the charter would require us to hold elections for those at the next uniform election date that's at least 75 days away. And the reason for that is we have that 74-day notification requirement to give to the county. So in theory, if our council approves or orders, a special election, we need the next day to get that information over to the county. And so that, under state statute, is really the earliest that we could hold an election. And so that's just to conform with state statute. And then for a recall election, the timing of that ballot measure would be the next uniform election date that complies with all statutory requirements. And that language doesn't have a specific number of days, because as I shared, the candidate filing period is different depending on which election date, which uniform election date we're using. So we can't just say, well, 74 days, because in some cases, the candidate filing period might be 94 days before the election. In some cases, it might be 64 days before the election. And so that language allows us as election officials to look at state statute and say, okay, this is the next uniform election date. I'm looking back. Here's the candidate filing. Here's when we have to provide notification. Here's the first election that we would be able to hold a special recall election. Next question, or next section. The fourth proposed change is clarifying calendar days versus business days. And just so it's very clear to everybody who is looking at our charter what the exact timing is of different aspects of the recall, referendum, and initiative process. The fifth change is clarifying the effective date of successful ballot measures. As I was putting my administrator hat on and reading the charter, one of the questions I had is, okay, so when are these items effective? When would an approved or successful initiative measure be effective? When would a successful referendum be effective, or a recall be effective? And so we've added those effective dates into the charter to clarify that process. So there isn't a question, should we have a successful ballot measure? And then number 6 is clarifying that ranked choice voting method is used for replacement candidates in a recall election. All right, now our policy items for your consideration. One of the things that we are suggesting is to change the time frame for the city clerk to determine the completeness of recall petitions. So, you know, when a recall committee I should say ballot referendum, ballot measure is coming before the city is being proposed, the committee has to submit a petition, and then the city clerk has to confirm that that petition is sufficient. It meets all of the requirements in the charter, and that we have to go through the list of everybody who has signed that petition and confirm that they are a registered voter in Bloomington, and that takes some time. And so we are suggesting changing that from 5 days to 10 business days, so that it gives us a sufficient amount of time to go through and take a look at the list of voters and look all of them up in our statewide voter registration system and confirm that those petitions are sufficient. So that is the first policy item for your consideration. Where are we going? You went.
Nope,
Do we do 2?
you went way farther.
Do you want to pause after each policy one and entertain questions?
It's certain.
Or just check and
Well,
see if
I wonder,
check in?
maybe should we go over to housekeeping first and see if there's any questions? Does that make
Yeah,
sense?
that makes a lot of sense.
Let's do that first and just see if we can. So commissioners, any questions on any of the housekeeping items? Any concerns? Commissioner Peterson.
What discretion does the staff have over the publication schedule? In particular, like in the effective date on the initiative is conditioned on its adoption and publication.
Chair and members, we used to have language in our charter that said specifically when ordinances were effective. A couple of years ago, we changed that because we were increasingly running into things that had a longer rollout period, and enforcement wasn't going to begin until sometime into the future. For example, the tobacco ordinance is one example. The CT conversion therapy is another more recent example. And so a couple of years ago, you all amended the charter to allow us to set a date certain. So it's the date certain that is provided, or the date that is published, whichever one it is. So if there isn't one specifically stated, then it's when it's published. The publication schedule with the Sun Current is things are typically adopted on Monday nights. They're signed on Tuesdays. They're sent to the paper on Wednesday or Thursday. They have to be there by midday Thursday, and then they're published the following week on Thursday. So that's sort of the cadence of it. So it's about 10 days or so after it's actually adopted that it gets published.
I guess my question was about what discretion does the staff have?
We, chair and members, unless the council provides a specific time period by which something would be effective, I don't believe that we unilaterally as a staff have discretion to create an effective date that's into the future.
So you can't,
You can't sit on
have discretion on submitting it.
Chair members, I don't believe that our office has that. Yeah. I don't believe that I've been provided with that authority.
Commissioner Stanley.
What definition of business days do we typically operate on? Because there are, a number of days throughout the year that are holidays for this part of the population and that for this part of the population. And so I'm clear as to how we define business days.
Sure. Chair and members, state law provides us with that guidance. There is a list in Chapter 645 of state statutes that lists all the recognized holidays. And then it would also extend to any one that the city council has determined as a holiday. So for example, some cities have added Juneteenth as a holiday and have closed their city offices. And so in that case, that wouldn't be counted as a business day for us. But It impacts sort of what are the holidays, impacts when you can be served and all kinds of other things. So if we did pass something like Juneteenth, we would need to figure all that out, or some other holiday. But right now, the holidays that we have are those that are published in Chapter 645 and any holiday added by the council.
So it's real cut and dry.
It's quite cut and dry, yeah.
Any other questions? I have one, and that is the update timing ballot measures, and this is just kind of the wordsmith in me. Where we say next uniform election date, does it make more sense to say first uniform election date? And again, it gets back at that aspect of, you know, not sitting on things, and that's just a, I mean, I understand next also kind of says the same. Just a thought. Commissioner Peterson.
So just another comment is I think on number 2 up there, while it could be read one of 2 ways, I think most people would have read that as being got to look to initiate something different. So I don't think that that's going to be a surprising thing to anyone. That's, we kind of report for the voters in Bloomington, so I kind of in favor there. Certainly of that. So even though that could be argued as a change, I just don't think it. Even if we took it off here and put it on another list, I would still.
Okay. Any further discussion? Questions?
Sorry
Go ahead.
to recommend me. I think on the next slide, it had a number 5 was about the, sorry, Adrian, would you mind flipping things? It's about the effective dates for ballot measures. You were saying that it just wasn't clarified before. I guess I was wondering just kind of where you got the new effective dates from.
For the referendum ballot measures, we are clarifying that the effective date, basically at the time that a successful referendum passes, is, you know, that ordinance is not effective. And actually, the ordinance is suspended at the point that a successful petition, petition is deemed sufficient by the city clerk's office. And so the ordinance remains suspended for a referendum, or for a it's a referendum until a special election is held. And then once that election is held, if the outcome of that election is to have a successful referendum and appeal or repeal that ordinance, then the effective date is that election. Never, the ordinance doesn't get put back into place, I guess is the way that you would say it. For a recall election, we have the effective date of a successful recall as 8 calendar days after the canvassing board certifies the results of that election. And the reason for that is that the canvassing board certifies the results, and then a candidate in the election has the opportunity to request a recount up to 7 days after the canvassing board meets. So after 8 days, we know there's no recount. We know that election, those results stand, and there isn't any additional work that needs to be done in counting those ballots. And so that was the effective date that we derived for the recall election, and that's how we arrived there.
Commissioner Stan?
Returning to Commissioner Peterson's point on the language, registered voters. Just to make sure I understand, you like the change or you didn't like the change?
I'd like to change.
And then I have a question about the timing of verifying the recall signatures and so on, going from 5 to 10. And is that just because it's nearly impossible to accurately do in 5 days? I'm just wondering about the change. It does seem pretty short, but.
Commissioners, that is to just provide myself and my staff additional time to go through and certify all of those signatures. What we need to do behind the scenes is actually look every voter up in our statewide registration system, make sure they have, a valid registration within the city of Bloomington. And depending on how clearly or not clearly folks write, that can be sometimes a challenge. And so it's just to provide that additional time so that we make sure that we're accurately and completely reviewing that.
Commissioner Stanley?
Is there any feeling amongst the commissioners that there's a reason to hold it at 5 days?
I guess I would be curious, like if that's the standard, 5 days is common, or it does seem short to me. 10 days seems reasonable, but I guess by comparison, I don't know. Curious about that.
Commissioner Peters?
It's more important to get it right. That timeframe is between 5 and 10 days if you think about the whole thing. Like a hugely meaningful thing. Theoretically, the ordinance would be in effect for 5 more days. But I think it's more important for the answer to be right into the law. I support the 10 days.
So you're comfortable with the 10 days?
I think so. I just doesn't seem
I
like
just didn't know if there was an argument for.
Yeah, no, I was going to ask the same question. Good
It's a very
question.
reasonable time frame.
Commissioner Lindell, did you have?
I just said it's a very reasonable time.
Oh, yeah.
10 days, I think.
Commissioner Hunt?
My thought is it's probably one of those maybe older hanging things in there when the city was much smaller.
Yes.
9-day period, and then you just go through a lengthier process now.
All right. Any other comments, questions, concerns about the housekeeping issues? Now we can move on to the policy issues.
It's your fire call.
We just had this discussion since I had presented on it, the timeline for determining the completeness of those petitions. Number 2. Number 2 is clarifying the process for referendum committees and petitions. And when I put my administrator hat on and I was reading our current section of our charter regarding referendums, it states in that section of the charter that a committee formation is required, but it doesn't provide the deadlines for when that committee would need to be formed, when they would need to submit their names and register with the city clerk's office, and then it doesn't address the need for any notification of a potential ordinance repeal. So there's some things in that referendum that aren't a referendum section that aren't particularly clear. And so what we're suggesting is this proposed referendum process. So within 15 calendar days of an ordinance effective date, a committee is formed by submitting their names to the city clerk, and that committee is made up to 5 registered voters within the city of Bloomington. Within 15 days of that committee's formation, they would submit their signature petition to the city clerk's office. Within 10 business days, the city clerk determines if that petition is sufficient. And if it is not sufficient, the committee has an additional 15 days to add signatures. And if it is sufficient, council considers the repeal of the ordinance followed required notification.
Any questions on this particular item? Commissioner Brown?
It seems to me that the change in 5.10 referendum is actually eliminating the suspension of the ordinance upon the filing of committee's intention to challenge it. And I'm wondering, that seems to me a pretty substantial change. And I'm wondering what the reason for that is.
Sure. It's in there.
Commissioners, so as part of this process, and one of the pieces that wasn't particularly clear under our current language is when that ordinance would be suspended. And the way this is currently drafted, an ordinance would be suspended upon the city clerk determining that the petition is sufficient. And so it wouldn't be at the time, and that's a policy decision of when is appropriate for that ordinance to be suspended. Is it at the point where 5 registered voters are submitting their names, or is it at the point where a sufficient petition has been submitted to the city clerk? So the way it is currently written, it is when a complete petition has been submitted to the city clerk and the city clerk has found it sufficient.
Chair and members, that's been moved to 5.13. Chair members, we thought that that seemed like an appropriate time in the process to do that, because at that point, they had submitted the petition. You know, it's one thing to submit the names and to get it started, but at that point, they're actually pretty far into the process. And it seemed like at that point, the suspension would be appropriate. I will say, just as an aside, that we field questions, and I'm sure the city clerk's office does as well. A lot of questions about, you know, can you provide me with the form to do this? Can you provide me with the information to do that? And people oftentimes are sort of feeling out things, like, do I want to do this? Can I get organized? Do I, you know, what do I need? And all different kinds of things, you know, from a speed bump to a sign to a whatever. And so it seemed a little premature to suspend it right away at the beginning. But again, it's a policy decision for you all.
But that's a change from the existing charter.
Chair members, correct. In 510, the current language says, on that filing, the operation of the ordinance is suspended and council must reconsider, et cetera, et cetera. That's about halfway through the struck language in 5.10. And the proposed language is in 5.13, which moves the suspension to when the petition is found to be complete by the city clerk. That's accurate, right, Christina?
Actually, Ms. Manager and Commissioners, so right now the current process doesn't really address the timing for that committee. And so it kind of jumps right into the point where the committee is submitting the signatures and submitting a sufficient petition. And so it does suspend the ordinance at the point that that committee has submitted a complete petition, removing where that is. And so it actually isn't a change from the current process, but the timing is a little bit different because right now the way it's written is you have the ordinance goes into effect and then the committee has 15 days to gather signatures. Under this, the ordinance goes into effect. The committee has 15 days to form. They have 15 days to gather signatures after that. And so that timeline changes. And so it does kind of push out when potentially that ordinance is suspended. But the actual suspension is at the same kind of trigger point, if you will, as it is in the current ordinance or current charter.
Thank you. Thank you. See, we all need to clarify.
Also, Mr. Chair.
Yeah, Commissioner Barnes.
Why is it that we eliminate the qualification reference in by 0.11 to compliance with 5.04 and 5.05 in the formation of committees? I don't understand why that's eliminated.
Commissioners, and this is part of the kind of confusing part of this section, or the unclear part of this section regarding referendums, is that we state in our current charter that a referendum committee must meet all of the requirements that an initiative committee does, but then it doesn't provide us with any timelines for when that committee needs to submit to the city clerk, what they need to submit. And so what we've done is, instead of referring back to the sections where we're talking about a committee for an initiative, we've added a section in there that specifically addresses a committee for a referendum and what that timing looks like and what the requirements are for that committee. And so then it's not necessary anymore to point back to the initiative committee in that process.
Chair, I would add that it was again an attempt to clarify instead of sort of the flipping back and forth and trying to kind of fit the circle in the oval. For each of the 3 different processes, we decided it would be just specific and give the process for each one, for both initiative, referendum, and recall, all in one kind of grouping.
Commissioner Stanley.
Just a comment that as a matter of policy, always be in favor of language specific to the matter at hand being in that section, little referring to anywhere else in the code as possible, because it's just asking for trouble. We'll change things. So, like,
Commissioner Peters.
So I just want to ask a clarifying question. So the current process effectively provides a 15-day window that starts on the ordinance effective date and ends at the submission of the petition. If the petition at that point is not adequate, then that process is done and kind of start over. In the current.
Mr. Chairman.
One of the, are we still, I mean, what's that?
Checking.
Yeah.
Always check before I speak.
I'll get you next.
Correct.
Okay, thank you. So based on that, so the way I think about this, there's kind of a trade that goes on it. That you have an ordinance and go, you kind of got to get out and rally people. Right now, is if you rally people and do that, then the ordinance gets suspended until the referendum process occurs. But I think of those 2 things as kind of being put together. We're not going to give you forever to go get signatures. But if you go and promptly get them, you get to have the ordinance suspended period of time. My concern, it's not about the structure, it's around the timelines. I think the timelines in the proposal are too long. And that trade between the ability to kind of cause the ordinance to be suspended and needing to get out there and do it kind of gets broken. So, like, if I was, and I'm just kind of thinking out loud, so I'm open to it. If I was looking at this and wanting to tweak it, I would change the committee date to 5 or 10 days. I would take under the second bullet from the bottom where you get another bite at the apple, you go off signatures, I would make that be shorter. And just the reason is I think I'm trying to kind of strike that balance, kind of maintain the current balance that we have between those 2 factors.
Thank you. Any staff comments on how you came up with this timing? Any comments on that?
Commissioners, when we came up with this timeline, we were kind of mirroring the initiative process. And typically that is 30 days for each of these steps. And so we shorten that in half and have the 15 days. And that was kind of our, knowing that we would want something to move through a little bit faster, but I wouldn't say married to this particular.
So those numbers are really policy.
Correct, they're policy numbers.
Further comments on this particular commented question? Not.
Can we hear a repeat of what you said, Chair?
When I just said there, so the 15 calendar days, those numbers in there, those are a question of policy that we can decide. We're not driven by state law.
Right. And you're interested in what was the proposal?
I have thrown out just as an idea, and I'm more just to kind of hear reaction and people have reaction to it. So shortening that first 15 in there to like 10 or 11.
Okay.
And then taking the opportunity to kind of go back out and make that shorter as a way of kind of trying to track more close. Because I think there's no situation, I think, today where the effective date of the ordinance, people aren't aware until the effective date. You know, the people who are going to be out running a referendum on the ordinance are going to know about it probably 60 days before the event. Because it's going to be at the council, it's going to be talked about, sort of. So I don't think it adds a whole lot to the time frame that people get organized to put a lot of time. Thank you.
I guess I just would say that I was comfortable with those numbers. It just felt fair. So just keep it simple.
Sounds like we have some, Commissioner Lundell.
Yes, just a question of how often have we this referendum and initiative and recall process in Bloomington's recent history? I don't know.
How long is recent?
Yeah. You know, is what Mayor remembers, I can say during my 5 years, the initiative and referendum process, those two processes were a part of the Jennison litigation. The organized hauling litigation. Yeah, there were, the process itself and which process was used was a part of that litigation.
Okay.
And Commissioner Barnes, you waiting.
Well, it just occurs to me, back on eliminating 4 and 5, point 4 and point 5. In this reference, it seems like you're giving up several requirements. Specifically, the formation or the petition is now 10% in 5, and it appears to be 15% in the modification. I'm not sure why that reference is, or why it isn't, why those requirements are not picked up if you don't want to refer back.
Future slide, you're going to talk about the percentages, right?
We are. In this, in the current proposal in front of you, we haven't changed the percentages for referendum or initiative. In the referendum section, we have moved things around a little bit. And so previously, the 15% was under 5.10. And so it actually moves to 5.11, just as a formatting piece, but the 15% threshold still exists for a referendum petition. We're not proposing a change in this document.
It sounds like we have, we'll be discussing these to process the timing, the days in the future, but let's move on to the rest of the policy presentation. Because as we noted in the beginning of the meeting, they're pretty interconnected.
The next policy decision that we're asking you to consider is the timing of initiative elections. Currently, our charter says that initiative petitions with signatures between 10 to 15% of votes cast in the last regular municipal election are placed on the ballot at the next regular municipal election. The proposed language put those petitions with between that 10 and 15% of votes cast on the ballot at the next regular election. And so this would allow us, let's say we receive an initiative petition at the beginning of 2022. And instead of waiting until the next regular municipal election in November of 2023, this would allow us to place it on the ballot during 2022 at the next regularly held election.
Question? Would you like to also talk a little bit about costs? That was one of the things that I think that might be relevant. Would there be any costs associated with this?
So this one actually wouldn't be wouldn't really have a change in the cost for the election because we're still holding it at a regular election. And so it would be an already budgeted election. The initiative petitions between 10 and 15% do not trigger the need for a special election. But right now it's the requirement is to be held at the next regular municipal election, which as we know are an odd number of years. And so there is potentially a very long lag time if we receive one in an even numbered year. Our current language wouldn't really allow us to put that at the primary or the general election for that even numbered year.
All right, now I'm going to suggest we proceed with the overall policy presentation and then come back to the slides where people have questions. So let's make our way through the rest of it. Again, because of the interconnected nature of this.
Yep, sorry, go ahead. The fourth policy discussion is when an officer would be eligible for a recall measure. Our current charter allows for, basically says any officer is eligible to be subject to a recall measure. The proposed language would change it so that an officer who has at least 300 days left in his or her term would be eligible to have a recall measure. And that puts us at approximately March 15th of every year. The reason we are suggesting this is because once you get past about March 15th of every year, the time that it takes to have a recall petition, have it certified, hold your, submit a notification of election, hold the candidate final, getting to November at that point is when the election would actually be held. And so under our current charter, we could have a situation where there is a successful recall election and then special election to fill that position for a position that is also on the ballot in November. And so this timing would allow it so that basically by March 15th, that's when we would need to, that's about the time you would need to start in order to have it on the August ballot. And so this would allow a recall petition to be on an August ballot, but it would make it so we don't end up in a situation where you have a ballot that has both a recall and a replacement and then a new election for that candidate on the same ballot.
So this would give those interested sort of a last possible date to initiate their process.
That is correct.
Rather than it coming a month after that and finding out that there's no way that their recall measure can possibly, come to fruition in that election. So you're really just saying this is your last possible day.
That's correct.
Chair members, I'd also add, it helps to prevent the situation of the voter being totally confused as to what they're voting on as well. If there is the recall and the replacement and then the new person, it would be difficult to explain. And also there are limits, very strict limits, as the city clerk knows, with regard to how much help the election judges can provide. So I thought that was a helpful benefit of this particular item as well.
Commissioner Peterson.
There was another situation, charter that eliminated the same condition of the same person being found twice. That has been eliminated from the charter, and it was a situation where someone resigned from the city council. Someone was appointed, and they had to run for election in November for a seat that was good for November and December. Then they had to run separately at that same November election for a seat that started in January. It caused an enormous amount of confusion. So back in the day, that condition got eliminated from the charter in order to prevent that from happening. So this sounds a lot like that.
The fifth item for policy discussion regards the signature petition threshold for recall measures. Our current charter states that all recall petitions must have 25% of the total voters who voted in the last preceding municipal election. So it doesn't distinguish between citywide offices and council member district offices. Our proposal is to not change anything for the citywide offices, so that would still be 25% of the total voters who voted in the last preceding election. But for district offices, the required number of signatures would be 25% of the total number of registered voters who voted in that district in the last regular election where that office was on the ballot. And those signatures on that petition would need to be from voters within that district. And I have kind of, on the next slide, I have an example of what those numbers actually would look like using data. You can go ahead to the next slide. So in this example, I just used our most recent elections to show kind of how this would play out. And so for our current language, any of our council district offices or citywide offices would need 4,511 signatures on that petition. Under this, our citywide offices would still be at about 4,500, but then our district offices, that does decrease because there's fewer number of votes, right, that are cast in each of those districts during those municipal elections. And then it also clarifies that these signatures need to come from voters who reside in that district. So if I live in District 4, I can't say, yep, I want to recall that council member who lives over in District 1. And so that provides that clarification.
Which adds to your work in verifying legitimacy of these things, because now you're not just looking at whether or not they're a registered voter, but what district, and therefore the 10 days.
It does. We certainly appreciate that 10 days.
Commissioner Peterson and then Commissioner Stanley.
I just want to point out the situation that you're trying to avoid here more specifically is that if you look at that currently with 4,500 people, that's more voters than voted in District 4.
Right.
Which clearly that just is a nonsensical outcome of the
Absolutely. Yeah. Commissioner Stanley.
Good.
All right.
And the last policy discussion on here, we're not suggesting any changes to the signature thresholds for initiatives and referendums. We haven't changed that in the current draft of charter amendments. However, this seemed like a good time while we're looking at all of these pieces of these ballot measures to review if these are the thresholds we want to continue with into the future. And so just to remind you, for initiative, if we want an initiative measure held at the next regular election, the petition needs to have signatures from at least 10% of the total number of votes cast in the last municipal election. And then to trigger a special election, it would require 15% of the total number of voters who voted in the last municipal election. And then for a referendum, which is held at a special election, those signatures are from at least 15% of the total number of votes cast in the last municipal election. And to kind of help us look at what those numbers are, to give you an example of how many signatures that is, we'll go to the next slide. And so this gives you an idea of kind of what we would be looking at for how many actual signatures using our data from our most recent election. So you can see that for an initiative, if it's held at the next regular election, that would be about 1,800 signatures. For a special, it'd be about 2,700. A referendum would again be about 2,700, about 15%. And then if it were me, I thought, well, what are other cities doing? And so then I also went through, I apologize because this is a little difficult to read on a PowerPoint slide, but we did go and look at what other cities have for their thresholds for triggering an initiative or a referendum election.
So we're in the range. Is the short version?
That is correct.
Commissioner Stanley.
I just want to say that would have been my next question. So, thank you.
Okay, thank you.
Can you go back one slide? So I support leaving the same. I think for example, I think the trash initiative was legitimately, an issue that people should have been able to go down the neck. So I don't think that is. I also don't think it's a failure that doesn't happen very often. So it seems like we're hitting the spot between too often and not too often. when I look at these numbers here and I think about how would I budget my time to go through that, my estimate is I could get 10 signatures in an hour. Yeah, going out and knocking on doors with something that was reasonably popular. So that seems like the right magnitude of effort to make people go through.
All right, proceed.
That's the last one.
So
Commissioner Stanley.
we're over this whole section now?
Yes.
Policy. Okay. Few slides ago, there was a phrase 10 to 15%.
Thank you.
It's lost on me as to why there's an upper range on that. Thank you. Initiative petitions with signatures, 10 to 15% of vote. I don't understand why it just doesn't say 10% or more. I think that's what I'm getting at anyway. Why is there a range?
And that's not so much language from the charters. I was just trying to clarify that we were only talking about initiative petitions that fell within that 10 to 15% range versus the ones that have signatures from 15% or more. So that's language I put in the slide just to clarify what type of initiative petition we were talking about and the timing of when we were talking about that. In our code it says, or in our charter it says if it's more than 10% it shall be held, and then it says if it's more than 15% it shall be held. So that was just for me as I was presenting. No.
10 to 15%.
It was more than 15. Oh my God.
No, more than 15, then it would require a special election at the next uniform election day.
All right. Any other questions, comments, concerns, Commissioner Stanley?
Do we benefit from language that says 300 days before as opposed to a specific date like your March 15th? Personally, I find it, we start talking about, well, it's got to, it's going to be 75 days before this, and then I got to, wow, I got to count backwards. And is there enough difference year to year to year to year to year where simply picking a date where we might be plus or minus a few days from that 300 days? Is there a benefit or a reason to do one or the other?
Commissioners, I would say there isn't really a benefit to doing 300 versus March 15th. The timing doesn't change that much between election cycles and between election years, where a couple days difference would really impact any of these processes. So I think it's just a matter of preference for wording and clarity.
Yes, legally there's some issue, but as a practical matter, and especially personally, I've always preferred specific dates to work from.
Yeah.
Right. Yeah.
And as long as it isn't.
Easier to understand.
But chair members, the only thing I can think of is that there is some sort of weird occurrence where there might be a term of some sort of different length. I don't know. When we draft these things, we try to think of every possible scenario that might play out. And again, frankly, for all of the dates that have been put in here and all of the calculations of time, they're all based on the most current version of state law. So if the state legislature does what it did several years ago and totally redoes, these uniform dates, we may need to do some cleanup. But at a minimum, we're cleaning up the stuff that we need to clean up now. Our choices, just sort of generically, are to remove a lot of these timing, 300 days, March 15th things, and then enter into a sort of an argument with somebody that it's not possible for you to accomplish this within the time that's available. We can't meet our statutory obligations. And then they, they don't like that, and push back on it. So I think there's a trade-off here in saying 300 days or March 15th or whatever route you choose to go.
Could we cover ourselves by saying, picking the date, March 15th, whatever it might be, or a minimum of 300 days? Because that's what we need to.
Doesn't change the need to do the math.
Yeah.
Yeah.
And introduce the possibility of a little bit of argument and ambiguity.
Yes.
To me, if we're talking about 10 days or on October 15th, short time periods, well, then the difference between a 10 days before versus a specific date becomes more arguable and a more potential issue. But when we're going out 300 days or March 15th, I would think we would be safe
Right.
and clean and clear. Said
March 15th.
Yeah.
March, whatever, yeah.
Yeah.
That's a good point.
My thoughts.
Commissioners, the reason that I likely suggested it and drafted it this way versus the March 15th is just when you get into election administration, so much of what we do is you start with this date and then you count back, and you start with this date and then you count back. And so you get kind of into a groove of counting, right? And measuring everything by the election date. But in this case, I don't see any issues with using a date certain March 15th versus the 300 days.
Any other questions or comments? So it sounds like we have a couple of issues to solidify here. We do have on potentially, or on the calendar anyway, a meeting next week to finalize this, but it seems to me, and I'd be interested in your input, there isn't enough difference tonight that we couldn't possibly act on it. I'm just wondering how the board feels about moving forward and acting on this evening. Commissioner Peterson.
Mr. Chair, maybe the approach to take is to walk through the changes and have conversation and vote on modifying this. And if it turns out, if it happens, that it's in a position where it's adoptable.
Chair and members, I've been tracking the items that I've heard are sort of points of that where we aren't on the same page. The one that I have two, the one is the use of the term the next uniform election date. And then I'm hearing this 300 days versus March 15th. In both instances, we would need to redraft the sentences. And we could repeat them into the record as a way of making sure it was clear that everybody understood what they were voting on. And we could do that. The risk is that we might miss something along the way. But just to be clear that is, the risk that we have. I have electronic version, I can search on words and, that sort of thing. Are there other points of concern with the language that's in the document right now?
I'd like to have a conversation about those dates and see if there's a consensus. In terms of the.
Oh, right, that was the other one.
Yes.
Thank you. I wrote that down here.
So, Mr. Chair, I'll start by asking the city attorney, do you want to spend a minute proposing some language around the 300-day to March 15th day and read that back to us? This would be on page 16.
Yeah, 515.
Yeah.
Just a show of hands, I mean, how many people, if we can work out the wording, would be comfortable with acting tonight, or is there a strong feeling? Okay.
Okay.
Anyone opposed to that? Okay. I'm going to call a quick break because I have to use the restroom.
We have to redraft the sentence
That's
here,
right.
so
What's that?
we have to redraft the sentence here. So
Yeah.
do you want to recess, a motion to recess, and then do a vote?
All right.
I hope that we recess until 8:27 p.m.
Motion to recess until 8:27. We have a second.
Second.
We have a second. All those in favor signify by saying aye.
Aye.
It carries unanimously.
Same thing. Okay. Okay, so I want you to erase what I said.
Okay.
Say it again from the top. So that I can say it. Okay. Starting on page 14. Okay. In section 5.2, which is about the formation of the committee. that's going to reflect the change. That second line, I told them to reduce that time from 15 to 10 days.
The reason being,
And the overall, the reason for both of these changes is currently you have, if you have 15 days from when the ordinance takes effect to go collect the signatures. Okay. The proposal here effectively would create a period that's 30 days long, plus this 15-day period up front. So it substantially lengthens the period that we can go and collect signatures. And I think one of the goals of, and if you do that, you get to cause the ordinance to be suspended. Okay, so it's a powerful thing to do. And there's a balance to be struck between the ability to go and cause an ordinance that our elected officials put in place to be suspended. I like how the current charter language puts people in the position. People have to be worked up about it enough that they're going to go out and get the be done. So what I'm trying to do is to maintain somewhat the same balance that the charter has right now by reducing those time frames. And not having just an extended period of time, a longer period of time. Because I think it tilts it too much in the direction of making it too easy to suspend. So to just talk about the changes in 5.10, second line changing 15 to 10 days. And then in 5.12 on page 15, this is where I think I'll say it right this time.
I don't think all of our page numbers
I don't
is the
think,
same.
yeah, you want to stick with section numbers.
Okay, stick with section. So then, because I'm the one in the main. Okay, so
Yeah.
so then in section 5.12, and 5.12, in the fourth line from the end, it says referendum is 15, changing that to 10. And then in the second to last line where it says if at the end of the 15, changing that, those two numbers have to match. So what that does effectively is it shorts the period up front after the committee is formed to get out and get signatures. It shortens this second bite at the apple to go get more signatures into your petition.
The first line stays the same.
The first line stays the same because the first line, that's the,
Is at 15.
that stays at 15. The reason
Right.
that stays at 15 is that's the 15 that we have today.
Right, okay. And then the second.
Yes.
Okay, very good.
Commissioners, any comments on Commissioner Peterson's proposal here? It is not a motion yet, correct?
You made a motion.
I did make a motion, but I took it back.
Yeah.
So we can have a discussion.
Yes. So any thoughts on Commissioner Peterson's suggestions here? Commissioner Salmon.
Commissioners, in general, I lean towards this matter of policy, making things as easy as it is practical for our citizens to do things. And to the extent that changing this length of period to a shorter length of period were to make that, if in fact it were to make it any more difficult, standing in a series of trade-offs. I don't know enough about the work with the city government to know that 15 days versus 10 days doing this or that or the other thing is all important to them. It's a matter of policy or practicality from the staff standpoint. So I'm not disagreeing with you, and I have no reason to vote against your proposal. I don't have a real good sense of what those trade-offs are, and to the extent that anybody else does, to felt that 10 days was too short, comments like here or there.
Commissioner Stanley, I share some of those concerns as well. I don't think we want to have barriers. So, Commissioner Peterson.
You have a slide that shows the thresholds for the member votes.
Yes, we do. Page through to policy discussion 6.
So yes, I'm looking for it. Okay. So at its core, the referendum kind of suspending the action of the ordinance is an anti-majoritarian sort of thing, because a small minority of the people in the community, that number of 80-some thousand people, can cause an ordinance to be suspended. And so I actually don't think, normally I'm like, hey, I do want to have people come in. But I think we have to strike a balance between allowing a small group of people who might have a heartfelt opposition to something to suspend something that is in the big picture popular. So that's what I'm trying. I don't want to be too hard, and I don't want to be too easy.
So would it be solved by the timing of when the ordinance is then suspended, as we discussed earlier, as we talked about that time?
You know, I thought a little bit about that, but what I'm trying to do is to not change it too much. And that right now this ordinance suspension is something that's currently in there, and I'm not convinced that that's a bad thing.
Thank you. Any other thoughts, concerns?
Mr. Chair,
No.
I think the 15 calendar days is reasonable, and I would be in favor of maybe changing the correction period to 10 days because they, didn't do it right the first time, and they still have 10 more days to make it.
And it's currently 15.
Okay. Yeah,
Is that right?
15 would be, keep the 15, and then
And yours was, your suggestion was?
I think he said 10 on both.
Yeah, so currently, got the chart, the convention.
Right.
Okay. The proposal from the staff is 15. So that's all.
Okay. Any other discussion, concerns?
I guess, when looking at the original numbers provided by the presentation, that looks like reasonable opportunity for voter participation in government. And when looking or considering change in numbers, it seems like a window, a shorter window that I guess I'm just supportive of the original numbers.
Thoughts? All right.
Well, I'm not that knowledgeable about how government's run, but I think we should leave the opportunities for people to be involved, make it easier rather than harder now. But how that's done, I don't know. Well, that's kind of my thought.
Commissioner Bowers, did you?
I'd be in favor of leaving 15. That's a fact.
All right. Any further discussion? What's that?
I'll withdraw my proposal.
So we'd be looking for a motion at this point?
No, I'm not. I'm going to withdraw my proposal.
Oh, okay. You're welcome. Okay. So.
I have one more.
Okay.
Yeah, okay. So Chair and members, the other one that you asked us to look at is the 300 calendar day, the 300 calendar days. We took a run at it about 5 or 8 different ways of trying to parse the language. And unfortunately, in the time allotted, we were not able to come up with replacement language. The challenge for us is a couple of things. One, the fact that the term doesn't technically end until the successor is appointed, and all kinds of strange things can happen. And it doesn't happen in the same calendar year of the March 15th deadline. It's actually usually the next year. And so we weren't able to come up with replacement language in the time provided. We can certainly go back and try, but unfortunately, we were not able to do that tonight.
Is it a matter of not being able to come up with a language, or is it still relatively strongly staff's recommendation for clarity that it be 300 days? I mean, you remain as comfortable with your original proposal now as you did when you came up with the 300 days?
Chair and members, yes, the 300 days works for us, and in large part due to the duration of that term, and it's not really tied to the passage of the calendar year. It's to that specific person's term. And so what we're trying to avoid is having multiple elections for that office on the same ballot, which relates back to the balance of the term left, and not really where we are on the annual calendar. Right?
Commissioner Stanley.
I'd just like to comment that despite my personal preference for date specificity, I don't believe that this rises to the level of importance that I'm interested in spending any more time on it than.
Very well. Any other comments or concerns? Now we'd be looking for a motion on this item. Could you state the motion, please? Have we, with any discussed agreed upon changes, which I believe.
For none. Is that correct? Chair members, is that correct? Or none? Is that presented?
We've passed, yeah, okay. And that's what I thought. So unless anybody feels strongly, Commissioner Barnes, you go ahead and make your motion. And that's probably that's yeah, exactly.
Adopt resolution 2021-3, a resolution recommending the city charter amendment by ordinance, amending city charter chapter 5 relating to referendum and meeting.
And do we need to add anything? Yes, staff outlined in the.
No, I think we're good now. Is that it? Okay.
All right, we have a second on this.
Second.
Motion by Barnes, second by Liddell. Any discussion of the motion prior to voting? If not, all in favor signify by saying aye. Aye. Anyone opposed? No one's opposed. Motion passes unanimously. I would also, at this point, I would entertain a motion to adjourn the meeting. Come on. Motion by Liddell, Taylor, all in favor signify by saying aye.
Aye.
Motion passes unanimously. Thank you, everyone.
Good job.
That was fun. Thank you so much.
You haven't seen fun.
No, this is a good one. I can tell.